Okay, we're going to get started. Thanks everyone for coming. We are in almost standing room only, and this is a very important issue. My name is Shereen Mitchell. I'm the current National Council of Women's Organizations Chair. I'm proud to have the ERA Task Force bring this briefing forward today. I have the honor, distinguished honor, of introducing the Senator. Senator Ben Cardin of Maryland is the author of the SJ Res 15, a joint resolution which would remove the ratification deadline for the Equal Rights Amendment. Ben Cardin believes government has a duty to improve the lives of all Americans, from expanding access to health care, to boosting job growth, to making home ownership affordable, to improving the environment. Senator Cardin is a recognized leader with a record of legislative success. First elected in the U.S. Senate in 2006, he was reelected in 2012. Senator Cardin currently serves on the Finance, Foreign Relations, Environment, and Public Works, and Small Business Committee. The Washington Post has said Ben Cardin has a command of issues, proven integrity, formidable intellect, and an unstinting work ethic. We're honored to have you today. Thank you.
Jerry, thank you very much for that very kind introduction. Thank you all for being here. This is really an impressive group of people that are here, and you've done so much over the years. And I start by saying thank you. Thank you for what you have done to make this country a stronger country. I have two granddaughters. This issue is important to this country. It's important to every family in this country. And we've made a lot of progress because of the people in this room and others who have fought for justice in this country. We have made progress in gender representation in the United States Congress. We're still not at where we need to be, but we've made progress. We've made progress in the workplace. We've made progress in all areas, but we're not there. We are still on that path. Paycheck fairness brings that out pretty clearly. We're going to be taking that issue up in the next couple of weeks. But you all know that if you're a woman, you're still working for free until sometime next week, I think, or the week after, when you finally get to the place of where you're equal to the pay that a man would get for a similar job. The inequities in the workplace and the paycheck is still prevalent here in the United States. We're still working on that. We're not there yet. And if you ever had concerns about whether things are going always in the right direction, listen to the Supreme Court debate this past week on the Hobby case and know that there is still serious issues of whether we will be on a continuous road towards progress or whether we're going to see some losses along the way. And there's so many other areas that we could talk about that we haven't gotten there yet. So I come here to say that we're still on that path for justice in America, for what is right, and for the economic future of our country. And I thank you for your persistence. You all live very busy lives. You do a lot of things that are extremely important in your own personal life, your family life, but then you find time to be here, to speak out for social justice and human rights. So you really are the heroes, and I want to start with that and thanking you very much for your efforts. So we're here today because we do believe that we can get the support to pass the Equal Rights Amendment. We can get it done. We can get it done. 35 states have ratified the Equal Rights Amendment. We only need 3 more states. And before I came up here, I was talking to a person who's working in Virginia, and she believes that we have a good chance to get other states to ratify if Congress takes the steps to say that the ratification process is still open. This is not a radical departure. As I think most of you know, the 27th Amendment that dealt with the pay for members of Congress took 203 years to get that ratified. We're kind of young compared to that particular constitutional amendment. This is an amendment that all of us remember. I remember voting for the ratification in the Maryland legislature. I was proud of that vote. Maryland's one of those states that has ratified the Equal Rights Amendment. And guess what? We're still there. It's only helped in our state. So it is well past time for the Constitution of the United States to provide for equal rights. And that's what we're talking about. Justice Scalia, who I rarely quote, has said there's nothing in the Constitution that requires discrimination against women, but there's nothing in the Constitution that prevents discrimination against women. Therefore, we don't have the protection that we should in our laws to speak to one of the basic values of this nation. I'm very proud of how we stand up to human rights violations around the world, and we do. Thank you for the values that we've taken to the international scene, how we stand up against abuses. But the first order is to take care of business here at home. And the ratification of the Equal Rights Amendment is exactly what we need to do. So we want to get a vote on this. We want to get this done. This is the year we think, let's do it. Let's put it on the floor. We're here to vote. That's why I ran for the Senate. It was to be held accountable for my beliefs and to represent the people of my state and to do what's right for this country. Let's put this up for a vote. Let's see where people stand on it. I think we can get the votes to pass the legislation. We have, I think we're now close to 30 co-sponsors of the bill in the Senate. 32, thank you very much. Keep working on it. I was hoping to be 33 before I finished my comments. Keep working the offices. So we are making progress on this issue. But your energy today can really help us get to the finish line here. So I just want you to know we have Democrats and Republicans that are on this. We don't want, this is not a partisan issue. It shouldn't be a partisan issue. Rights for all should never be a partisan issue. So let's do what's right for this country. This is not about what's right for women. This is what's right for America. And we stand united to get this done. All we need is 3 more states if we can get this passed in the Congress. 35 have already ratified it. Almost half the states have provision in their own constitutions that provide equal rights. This should be an easy decision for the United States Senate, for the United States House of Representatives, and I believe for the American people. So that's what we're here about, to develop a strategy to get more co-sponsors and ultimately to get these bills passed. And then we'll all work on getting 3 more states or 4 more states or even all 15 states to ratify this amendment to show that we are united as a nation to do what's right for women and do what's right for this nation. Thank you all very much for your commitment to this issue. Now I'll turn it over to the real experts here.
Thank you, Senator.
Thank you.
Thank you, Senator, for your remarks. Good afternoon. My name is Bettina Hager, and I'm the co-chair of the Equal Rights Amendment Task Force of the National Council of Women's Organizations. I want to thank you all for joining us for today's briefing on the Equal Rights Amendment. I want to especially thank Senator Cardin and his office for his leadership in organizing this event, as well as his sponsorship of SJ Res 15, the bill to remove the deadline on the ERA ratification process. Today, our panelists and experts will brief you on the current status of the Equal Rights Amendment legislation, give an overview of women's economic status in America, and outline the benefits that sponsorship, passage, and ratification of the Equal Rights Amendment will bring to our country. After the presentations, we hope to have close to a half hour for an important question and answer session with the audience. In addition to the speakers, we're very fortunate to have with us, at the request of Senator Cardin, 2 Congressional Research Service experts, Thomas Neal, a specialist in American national government, and Kenneth Thomas, legislative attorney, as a resource for answering questions related to the ratification process for constitutional amendments. For those of you who may not know, the Congressional Research Service provides objective, nonpartisan analysis to all members of Congress, working exclusively for the members and their staff. Our first panelist will be Roberta Francis, and she will be speaking about the traditional and 3-state ratification processes for the ERA. Roberta Francis, a gender equity consultant and writer, has been an ERA activist at local, state, and national levels for nearly 40 years. She currently serves as co-chair of the National Council of Women's Organizations ERA Task Force, whose founding she proposed in 1999. Francis, who was appointed by Governor Jim Florio to serve as director of the New Jersey Division on Women from 1990 to 1994, has worked extensively on a broad spectrum of issues for women's advancement, from education and pay equity to reproductive rights and violence against women. But the ERA was the cause of her feminist clique, and it remains her first love. Thank you, Bobby.
Thank you, first and foremost, Senator Cardin and Bill Van Horn, his Chief of Staff, and Tom Neal and Ken Thomas from Congressional Research Service. Are all great assets, obviously, in their various niches for this issue. And I thank personally Bettina Hager, my co-chair as ERA Task Force Chair for National Council of Women's Organizations. You don't know, the old commercial, priceless. Priceless is having a co-chair like Bettina, so thank you all. In 7 minutes, I'm going to give you the whole background of where we stand with ratification, et cetera. So, take a deep breath and roll with me here. The Equal Rights Amendment was passed by Congress in 1972 by a super majority. It requires 2/3, but it got far more than that. According to the traditional constitutional ratification process, it must pass by a 2/3 majority in each house of Congress, and then it must go to the states, and 3/4 of the states must ratify an amendment, and then it becomes part of the Constitution. 3/4 out of 50 states is 38, so that's the magic number we conjure with right now. On March 22nd, as I said, 1972, the ERA passed the Senate and House and had a deadline of 7 years. We'll revisit the deadline issue a little bit later. After about 6 years of the 7, it was getting a little tense, and the supporters of the ERA said, it's never been done before, but let's go for an extension of that deadline. And after a massive effort, that deadline was extended by statute to June 30th, 1982. However, when that second time limit passed, the ERA had been still ratified by only 35 of the 38 states. Bills reintroducing the ERA for ratification by this traditional process without a time limit this time have been introduced in every session of Congress since the 1982 deadline passed. And in the 113th current Congress, these bills are S.J. Res. 10, lead sponsor Senator Robert Menendez of New Jersey, the state I come from, and Bettina comes from, and H.J. Res. 56, lead sponsor Representative Carolyn Maloney from New York, who has been the lead sponsor of the ERA bill in the House for many long sessions. And we thank those lead sponsors. Now, this is untrodden constitutional ground, if you will, but from the beginning of the Constitution, a lot's been untrodden, and now we've trodden on a lot of it. So this is our latest adventure. In 1992, as was alluded to, we added the 27th Amendment to the Constitution. It's so-called Madison Amendment, which deals with congressional pay, and it was first sent to the states for ratification with 11 other articles, hang on to your hat, 10 of which became the Bill of Rights. 2 did not, out of that batch of 12, 2 did not get ratified, and this was one of them. And so our understanding is that someone in researching the Equal Rights Amendment in the early 90s came across this dangling amendment or article, found out that it hadn't received enough ratifications, but decided to go for the rest and got the 38, 3/4 total, and put it into the Constitution in 1992. The fact that this was accepted as valid, a 203-year ratification period, made feminist legal scholars say, well, then there can't be anyone who claims that ERA's first amendments in 1972 have aged out, if 203 years is okay. So the fact that that was accepted as valid for the Madison Amendment meant that ERA scholars said, well, let's look at, there's still another difference. The ERA had a time limit of 7 years attached, and actually, when people address the time limit, that seems like a stopper right away, perhaps. Okay, time limit was extended, but it's still, the extension expired. But There is a legal rationale for the validity of this process, and it's presented in Why the ERA Remains Legally Viable and Properly Before the States, which is the title of a law article that was published in William and Mary Journal of Women in the Law in 1997. And there is, I can circle back at the question time about details of this, but just so people know, there is a link to that article on the website www.equalrightsamendment.org. A link to a whole lot of other stuff on that on that website, which I hope you go to, because otherwise my work on the website is not paying off. But in any case, if you check into that law article, and we have summaries of it and so on, because the ERA's deadline is in the resolving clause, proposing clause is another word for it, and it's not in the body of the amendment itself, which was ratified by the states, there is a contention which could in fact be absolutely defensible, that could be changed by Congress not only when it did it in '78, but could do it again, and that's what the bill by Senator Cardin and the companion bill in the House was introduced by lead sponsor Robert Andrews, Congressman Andrews, who has now retired from the House. And do we know a bill number?
I don't know the bill number, but Jackie Spear introduced it.
Yes, Congresswoman Jackie Spear. Oh, super, thank you. I forgot to check before I stood up here to see if we knew for sure it was it. So that is how she picked up the bill from Congressman Andrews, and we get a bill number within a day or two, I guess, right? So check the website for that. But that is the companion bill to Senator Cardin's bill here in the Senate. So all of that is great setup for moving forward in the ERA, either through the traditional ratification process or what we're calling three-state strategy process, which was, in fact, Congressman Andrews in 1994 introduced the first three-state strategy bill, which was worded slightly differently. I believe in the packet, there's my remarks that I'm working off of here are in the packet, and you'll get a lot more chapter and verse of the details if you check that out. Now, the thing that I want to say was so wonderful is that Bill Van Horn in Senator Cardin's office last year when we had a briefing in the House came in with hot off the press, probably literally hot off the press, reports from the Congressional Research Service on the Equal Rights Amendment contemporary ratification issues. And Thomas Neal, I am assuming, sir, yes, great, was the author of that, and there was an update in May, very similar, but some update in May of last year. I just have to, again, another point of personal privilege. I was just astounded at what a tremendous job you did in a lucid presentation of what, even though I've been living with this for X number of years, it's so hard to put it all together. It was just a super job. And so they were passed out on the seats, I believe, the copies of the report. So bedtime reading. But more than that, you'll have a chance in the question and answer time to ask questions about all of that. And while I have much more I could say, and I'm being given the high sign, I just want to say there's another sheet that was on the seats that is, whoops, 2 key questions about the Equal Rights Amendment ratification process. We can deal with this in the question time too, but for the record, I would like to say short answers. Can states rescind their ratification votes? The short answer is some states have tried on a few occasions to rescind vote approval of constitutional amendments. It's never been accepted. When, for instance, my state, New Jersey, ratified and then rescinded its ratification of the 14th Amendment. And it was public, Ohio too did that, and those 2 states were listed in the ratifying states when the amendment was certified. It's never been accepted. Second question, quick. Isn't there a court decision saying that rescissions are valid and the extension of the original time limit was unconstitutional? I know someone at this table who could do chapter and verse on that. Ellie Smeal with Now was in the thick of that struggle. And the court case, which was handed down in Idaho District Court, said that it was an anti-ERA decision. It was appealed by now to the Supreme Court. The June 30th, 1982 deadline expired before it was argued and decided on, and so that decision was declared moot. It has no no power, no application. It was, what are the legal terms? But it was vacated and remanded. So lots more to talk about clearly, and question time is the time to do it, especially for the CRS folks here.
Thank you, Bobby. Our next speaker is Tritra Punjabi, Vice President of Membership for the National Organization for Women. And she will be talking about what women gain with an ERA. Tritra Punjabi is an intersectional feminist activist with a professional background in nonprofit management and fundraising. Punjabi was elected Membership Vice President of the National Organization for Women in 2013. Raised in Hong Kong, Punjabi's parents were immigrants from India. Due to her experiences of living as a minority in 3 diverse countries, she has seen firsthand how discrimination and inequality persist worldwide, and has thus committed herself to the fight for equality.
Thank you, Bettina. I want to start by thanking the Senator and his office for giving me and my colleagues the opportunity to speak today about the need for passing the Equal Rights Amendment. Thank you, Senator Cardin. My first introduction to the ERA was through my work with the Sewell Belmont House and Museum. Some of you may know it. It's that federal brick-style house on 2nd and Constitution. And I was a member of the development staff there. And I would often give donors private tours of the exhibits. The tour covered the history of Alice Paul's lifelong work with the National Women's Party to get equality for women. And it started with her fight to get women the right to vote. And then, of course, I would go into talking about her role in the first drafting of the ERA in 1923. I would share the campaign for the ERA and its history with my tour, and inevitably, whenever I mentioned that the ERA stopped short of being ratified at the 1982 deadline, people, especially the women, would look at me in surprise and say, "But I thought we passed it," or "What do you mean we don't have an ERA?" It was just unimaginable to the people on my tours that ensuring equality for men and women wasn't written into the Constitution, and the effort to do just that had been unsuccessful. I start with this anecdote because it's important to remember that equality under the law is something we expect as citizens and residents of this country. In fact, based on polls conducted as recently as 2012, 96% of Americans believe that women and men should have equal rights affirmed by the Constitution. That's near consensus. When is the last time that's happened? In the last couple of years. So the question is, what do women gain with an ERA? The answer is, quite frankly, a lot. To begin with, it would be an explicit guarantee that all rights protected by the Constitution would be held equally for all citizens without regard to sex. One might argue that the 14th Amendment's Equal Protection Clause does just that. However, the 14th Amendment has only been applied to sex discrimination since 1971, and legal scholars, including Justice Scalia, have said that in their reading of the Constitution, the document does not explicitly prohibit sex discrimination. The idea that equality for women under the law is open to interpretation is simply not good enough. With an ERA, we guarantee a clearer and stricter judicial standard when it comes to cases regarding sex discrimination. In fact, the passage of the ERA would greatly enhance sex discrimination law, which would provide equality for women and men. It's important to remember that the ERA's passage would have a real and direct impact on women's lives. This is especially true when we're talking about pay equity. My colleague, Dr. Gould, will be delving into further detail about the gender wage gap and the social impact of equal pay, but I would like to address this point briefly. The economic impact of women receiving equal pay for work of substantially equal or comparable skills and responsibilities would help close the gender wage gap and raise women and their families into better standards of living, and in many cases, out of poverty. This is especially true for women of color who were often disproportionately affected by the gender wage gap, earning much less than 77 cents to the dollar number that is often discussed in conversations about the pay gap between men and women. Recent research studies have shown that on average, African American women make 65 cents to a white man's dollar, and Latinas even less at 54 cents to the dollar. According to a 2013 report from the Institute for Women's Policy Research, if the pace of change in the annual earnings ratio continues at the same rate as it has since 1960, it will take another 45 years until 2058 for men and women to reach parity with pay. Health insurance is another area in which an ERA would have a real-world impact. Until the Affordable Care Act, women were charged higher premiums than men for the same coverage. The ACA now prohibits gender ratings, so women are no longer being charged more for the same coverage. However, if the ACA were repealed, without the guarantee of equality for the sexes under the ERA, the differences in premiums could be reinstated. When women are already earning less in comparison to their male peers, this puts an undue economic burden on women. It means that sometimes the decision to forego health insurance altogether must be made. And again, for women of color, that decision can be devastating. As a group, they are more likely to have difficulty accessing healthcare to begin with, and being uninsured makes that access harder. Passing laws to remedy these issues is certainly one way to approach it, but writing the ERA into the Constitution would truly guarantee what Alice Paul initially set out to achieve in 1923 when she first drafted it: equal justice under law for all citizens. Thank you.
Thank you, Chitra. Our next speaker will be Dr. Elise Gould, Director of Health Policy Research at the Economic Policy Institute. She will be documenting economic inequality by gender. Elise Gould, who holds a PhD in economics, joined the Economic Policy Institute in 2003 and is the Institute's Director of Health Policy Research. Her research areas include employer-sponsored health insurance, inequality in health, poverty, economic mobility, and the employer tax exclusion. She is a co-author of the State of Working the State of Working America, 12th edition. Thank you.
Great, thanks for having me here, and thanks everyone for being here for this important topic. I'm the economist on the panel, so we'll be talking about some numbers. I'd love it if you grab the packet. Out of your packet, there's a document here. I don't have a PowerPoint, so I'm going to be talking through some of the numbers. I think it's on the right side of your packet in the back. Take a second to grab that. So I'm going to start with a brief overview of wage disparities between men and women. If you look at that first chart, in 2013, the median hourly wage for men was $18.11 an hour compared to $15.10 for women. At that point in the wage distribution, the very middle, the median wage, women make 83.4% of men, or they make about 83 cents on the dollar. As you can see in that figure, this gap has been closing, though it's clearly that what's been happening is that typical men's wages have been stagnating as women's wages have been rising slowly. In 1979, women at the middle made about 63% of men, or 63 cents on the dollar. It's interesting, the statistics you just heard about how long it would take to close that gap. It's been more than 3 decades, and we've closed it about 20 percentage points, so it could take a lot longer to get from 83 to 100, you can imagine. The gender wage gap occurs at all levels of the distribution. As you can see in the next figure, the gender wage gap grows at higher points in the wage distribution, from about 92 cents on the dollar for those near the bottom of the wage distribution, shown as at the 10th percentile, to 76 cents on the dollar near the top at the 95th percentile. So the gap is much larger at the high end of the wage distribution than it is at the bottom end. Much of that has to do with the minimum wage, I would say. If you turn to the next page, you will see that women are concentrated in low-wage sectors. According to a recent White House report, women are also still concentrated in low-wage sectors such as healthcare support and personal care, and underrepresented in occupations with high average wages such as STEM occupations. Furthermore, the National Women's Law Center finds that women are 3/4 of workers in the 10 largest occupations that typically pay low wages. So we're talking about the 10 largest low-wage jobs, those sectors. And over 1/3 of low-wage workers are women of color. It's interesting to note that these jobs have dominated women's job growth in the recovery. 35% of the total net increase in women's employment over the past 4 years was in these low-wage occupations, nearly twice as large as men's. And even in these low-wage occupations, women working full-time make 10% less than men. If you look at the next chart, women are less likely to have workplace benefits. So it's not just about wages, it's also about benefits, employer-sponsored health insurance, employer-sponsored pensions. You can see in the next figure that women are less likely to have both insurance coverage and pension coverage from their job. The next page shows entry-level workers for men and women. As you can see, these are looking at both recent high school grads in the top figure and recent college grads in the bottom figure. And you can see the line for men and for women. And you can see that it's far lower for women, both recent high school grads and for recent college grads. So recent female college grads are making $9 an hour, as opposed to men, which are making about $22.67 an hour. So you see a pretty large gap there. Among those with advanced degrees, the gender wage gap grows throughout women's lifetime. The figure on the next page is from that same White House report I just mentioned, and it finds that men and women with professional degrees have similar earnings in their 20s, and then the earnings gap widens over time, so that by their late 30s and 40s, men earn more than 50% more than women. You see that gap in the figure. They also find in that same report that among all people who work full-time year-round, women make 70 cents for every dollar men make. You've heard that statistic before. A lifetime of earnings inequality means that women are more economically vulnerable in retirement. In a report that I did with some colleagues at EPI, we define economic vulnerability as having income that is less than 2 times the supplemental poverty threshold. It's a more comprehensive measure than the official poverty line. As the next figure shows, 52.6% of women ages 65 and older are economically vulnerable compared to the similar cohort of men, who are 41.9% of men are economically vulnerable. So much higher shares of women are economically vulnerable than men. In fact, the shares of men at every level of distribution above the economically vulnerable threshold, so you can see that in the blue boxes, are larger than the corresponding shares of women. And the shares of men are smaller at every level below the economically vulnerable threshold than the corresponding shares of women. So the red boxes for women are higher, larger universally. They're more vulnerable. It's important to note as well that this is not a statistical artifact based on the fact that women live longer than men, although women's longer lifespans do tend to make retirement planning that much more challenging. In fact, women are more likely to be economically vulnerable than men among both the young elderly and the older elderly, as shown in the next figure. Women ages 65 to 79 are 9 percentage points more likely to be economically vulnerable than men, and women 80 and older are 13 percentage points more likely to be economically vulnerable than men. I want to end with a great figure based on a recent work of Heidi Hartman and her co-authors at the Institute for Women's Policy Research, which shows how inducing comparable pay would have real benefits to living standards. If we want to reduce poverty, comparable pay is a great way to do it. As the IWPR reports, providing equal pay to women would have a dramatic impact on their families. The poverty rate would be cut in half, falling to 3.9% from 8.1%. You can see that in the first 2 bars of the next graph, the last graph. The impact on single women and single mothers with children is particularly dramatic. You can see how much poverty falls for those particular populations. Lastly, I want to say that there's no cost to the economy of women catching up to men. Workers generally, over the last 3 decades, have failed to see gains from a growing economy. There's plenty of room to increase workers' bargaining power for workers generally, reducing both the gender gap and increasing wages. Thank you.
Thank you, Dr. Gold. Our next speaker is Andrea Miller, the Interim Executive Director for Progressive Democrats of America. She will be talking about grassroots actions towards state ratifications. Andrea Miller, Interim Executive Director, Progressive Democrats of America, became Deputy Field Director of Progressive Democrats of America in 2010, and in 2011 assumed the role of IT Director and Congressional Liaison. Andrea is co-chair of PDA's ERA 3-state strategy team, voting rights, and end mass criminalizations. Thank you.
Good afternoon, everybody. Ooh, I'm going to have to step back a little bit. Big voice, big voice. Thank you so much, Senator Cardin, for giving us this bill, giving us this legislation. Thank you very much, Representative Speer, for being willing to pick up the ERA 3-state bill in the House. And again, We now have 110 co-sponsors. We had 104 before, so the numbers are growing. What I want to talk about is working on the ratification in the states. There are currently 15 states that did not ratify the original ERA. And big major surprise, many of those states are southern states. So the South was not willing to stand for its women. So what we've been working on at PDA is we've been working on removing the ratification deadline here in Washington, D.C., and in our district congressional offices. And we have been working on bringing legislation forward in the unratified states. And this is where we are right now. The state of Arizona brought a bill to ratify the ERA. It had been so long since they brought a bill to ratify the ERA, they had no idea what to put in the bill. So I get a desperate call. What should we say? So I sent them a copy of what we did in Virginia. Virginia has been introducing ratification of the ERA for a long time. We've even managed to pass it in the Senate a few times, and we were successful again this particular year in getting it through the Senate. Well, as anybody will tell you that's familiar with Virginia politics, we have the Senate, and then we have that other side. So we were able to get the other side to actually bring the bill up in committee. And at this point, I really have to thank a group of women who is seated, actually they're on both sides. I'd like to thank a group called Women Matter, Use Your Power, who made it a point to practically live every day in the Virginia General Assembly. And I know when I went to the General Assembly to speak to the bills, we were in the cafeteria. Virtually every staffer that came through that cafeteria stopped and acknowledged this group of ladies. They knew them all by name. The Democrats, the Republicans, they said, well, even if this isn't the right thing to do, they should pass it just because of your persistence. You're here almost as much as we are. So Women Matter, use your power. You really did use your power, and thank you so very, very much. Now, Florida has been presenting an ERA bill for forever. Our dear lady who presents it in Florida, dear Sandy O, is actually in her 80s now. So we're going to need the newer and our younger women to take this up, because I know as long as Sandy has breath in her body, she'll be wanting to bring this bill. But this is going to be all about, from this point forward, having younger women in their 40s, women under 60, take up this fight. Because those of us that are 60 and over, we're here basically, we're fighting for you, we're fighting for our daughters, we're fighting for our granddaughters. But we're gonna be gone soon. So we're gonna need you to stand up and continue the fight. Now, and I forget the really kind thing that someone said the other day about me particularly. So yes, there's still a lot of fight left in me, but I understand we're going to need to pass this torch. In Illinois, this is going to be our next big fight. So they have the Senate sponsor lined up, they have the House sponsor lined up, and we are going to need everybody to push this bill over the finish line. Yes, Illinois is an unratified state. They're unratified because it takes 3/4 of their legislature to ratify a constitutional amendment. It's a huge, huge reach. And it normally, when it was introduced and failed by one vote. So we are going to need everybody to stand up with Illinois and push this over the line. Missouri is also bringing a bill. So Missouri has a bill. They haven't had a bill for a while, but they've got a bill now, and Illinois is going to help Missouri. So the other states, Nevada, Louisiana, and North Carolina, based on the way their legislatures work, were not able to present a bill this year, but they will be presenting legislation next year. And Virginia presents a bill every year. So we will be back. We may have been disappointed, but we will not be discouraged, and we will not be denied. We will be back. So I'm going to invite everybody to one more thing. Notice our green ERA pins. What's really critical right now is that we continue to give the Equal Rights Amendment visibility. It kind of went away and disappeared from people's consciousness. We need to bring it back. At PDA, we're doing a series of teas, and we're calling them Tea with Friends of Alice Paul. And we're tying equal rights together with voting rights, because who is more vulnerable on the fight for voting rights than women? So we're combining, we're working to make this part of everybody's daily vocabulary. So please join us on September 13th for a rally where we're going to be, it's on Constitution Day, where we're going to be talking about the Equal Rights Amendment, and we're going to be talking about voting rights. So thank you all very, very much.
Thank you, Andrea. Our final speaker today is Eleanor Smeal, President of the Feminist Majority. Eleanor Smeal has led efforts for the economic, political, and social equality and empowerment of women worldwide for over 4 decades. She has played a leading role in both national and state campaigns to win women's rights legislation and in a number of landmark state and federal court cases for women's rights. Smeal is the founder and president of the Feminist Majority, co-chair of NOW's National Advisory Board, and the publisher of Ms. Magazine. From 1977 to 1982, as president of the National Organization for Women, Eleanor Smeal led the national drive to ratify the Equal Rights Amendment and to pass in Congress the joint resolution to extend the ERA deadline in 1978. This campaign was at the time the largest grassroots and lobbying campaign in the modern women's movement. The ERA campaign reshaped the contours of women's political participation in the U.S. and demonstrated the strength and breadth of public support for women's rights.
Thank you very much. And the reason I'm doing the cleanup here is that Bettina, and she is definitely determined to see this, wanted me to end with the fight to extend the ERA extension. Not because we want to be nostalgic, the job isn't done, but to tell you how doable it is. When we first got the idea, and it came from 2 young law students, that the extension could be extended, or the deadline could be moved to the future, most people thought it was a far-fetched idea at that moment in time. But we did our homework, and we saw that the deadline is not in the body of the amendment. It's in the preamble. And it was not voted on by the states when they ratified. It was only voted on by Congress. It was ruled that it only would take a majority vote. And so we started. Now, why? Because, you know, I think there's this invisible fact that we don't talk about. There was an opposition. Just like there was an opposition to the women's vote, there was a determined opposition to the Equal Rights Amendment. And that determined opposition did not always play fair in many, many ways. I personally think it was probably ratified in both Illinois and Florida, and I could go through that as another whole lesson. But the rules were constantly changing. And votes that were promised, people ran on them, they would switch them. And switch them in such a way that it was hard for us to get at it. Anyway, we went for the extension. I cannot even express to you how big that campaign was. Just to give you an idea of the size, when we marched, and this was the day when there weren't that many big marches, but we decided to march on Alice Paul's July 9th, 1978, which was, I think, her birthday. I can't remember, or death day. Death day, okay. It was, we weren't celebrating that, but it had a symbolic message. But the important thing was, it was in the summer session. We had to pass it by November of 78. And basically, when we marched, it was 100 and some thousand people on the streets, something like 125,000, which was really big then. I know that the last march that I helped, I was on the steering committee for, we got 1,100,000 in 2004 for reproductive rights, but that was how we learned how to do marches. This was the first march we had done since the suffrage of any major size. We went to Macy's, we went to the unions, we went to the peace movement. We didn't know how to do a march, so we figured out a recipe, and it kept getting bigger. But as we marched, this is a little statistic that I don't think many people know, over 400,000 telegrams, and I asked our young staff if they knew what a telegram was, and from Western Union, and I have to tell you, not one of them did. I really felt angry. But anyway, we sent 400,000 telegrams, and it would have been more, but we closed down Western Union, which was the only group that delivered telegrams on the same day. So it was a big campaign, and that was just the beginning of it. We went door to door. We went to every House seat, every Senate seat, and we only got out of the key House committee by one vote. This was close, and it was close in my opinion, and I don't know if I should say it, but I do think the financial interests, the business interests, the insurance interests, they were our major opponent. Let there be no mistake about it. There is, when we lead with economic equality, there are those who profit from charging women more for the same policies. There are people who profit for underpaying adult women, et cetera. And those forces are very strong, the moneyed interests. Anyway, we did it, we passed it, and we then went on. But we didn't do what we really wanted to do. The real original bill that was introduced was no time limit on equality. There was to be no time limit. You know, I can tell you all the slogans, and by the way, you don't need fancy, expensive consulting firms to think up slogans. The best time to think them up is in the middle of the night with your hardcore activists that just give it to you. Anyway, but there was no time limit. We wanted no time limit, and it was put onto the bill this short time in the House Judiciary Committee. We couldn't get out of committee, and it was put on in purpose because it was just enough time not to give us a new election for the state senates, because the senates are staggered, and it gave us short of 4 years, so we couldn't get at the state senates. And I could go, you know, so, and I know the exact person, by the way. And one guy voted 3 ways, by the way, on this vote. That's another little thing. But we filled the galleries. We filled all the hearing rooms. I'm so happy today is standing room only. And by the way, if anybody can't see it, this is intergenerational. And it was intergenerational then. I was young then, not so, but I'm not ready to check out. We're going to see this in my lifetime. You know, and I love what Gloria Steinem said. I believe on each woman having a torch, but I'm not giving up mine either. So the whole thing is, we need us all. We need the best of our brains. We need the best of our energy. We need everybody working and pulling the oar. The thing that's so exciting about the current campaign, and there are several going on, I want to salute the Oregon effort, where I don't know if you all know, but we are there's going to be an ERA ballot measure in Oregon. Petitions, this is a state ERA, are being circulated right now. We are the people circulating them are determined to pass it, and that's a spontaneous effort, grassroots effort. And I hope if you're in Oregon, you tell everybody to help us in Oregon, and then basically, in addition to that, there's all these state efforts. There's now the 3 state efforts. There's the Start Over effort. We're going to get it one way or the other. And it is coming not from the national level. This is coming from women who absolutely want equality in their lifetimes and now. So I feel enthused. Even though this is hard, just think of what happens if we don't get it. We are going to get it. And not only that, this effort is going to be global. We're going to pass CEDAW. We're going to get it ratified in the United States Senate. It is a disgrace that it hasn't been ratified so far. That's the Convention to Eliminate All Forms of Sex Discrimination. And we're going to keep at it until we get it right. And so I hope you're as enthusiastic as we are, and that everybody signs up. And I want to tell you another thing. We did it most all, and we keep doing it with volunteers. And I'm glad that Senator Cardin started this, and we're indebted to him by saying that people are here because of the love of the effort, because of the determination of the effort. This is going to be done by volunteers. And if all the women who care so much, if that gender gap would march in the numbers that we deserve again, it will happen. But it will really happen if we give it hope. And that why the 3 state effort is so important here in Congress is just to give it that hope. Frankly, I don't even think we need a congressional. I really don't. But I think it makes it real to people again. We need 3 more states. We need 50 states. I don't care what the number is. We need to ratify this. And where there's a will, there's a way. And if you got 5 votes on the Supreme Court, you win. That's the country that we live in right now. And I think we will have those 5 votes because the country is changing on all human rights issues. And people now are so proud of the women's rights movement. Remember, when we started this quest in the 70s, in the late 60s, we were a minority movement. Today, we not only have 96% of people wanting the Equal Rights Amendment, an unheard of number, we also have a majority of women who self-identify as feminists. We have all kinds of people who say they were there to pass the Title IX. I wish they were, but I'm glad they now feel they're aboard. We have all kinds of people who say, you betcha we have to have a Violence Against Women Act. It only took us almost 2 decades, or God knows how many times, to pass it, but I'm so glad they were with us then, and they're now with us. They weren't with us all then, but anyway, they're now with us. In other words, our movement is a growing movement. Who is bragging about standing in the doorway of human rights and women's rights? Nobody, not even Phyllis Schlafly. In fact, some of her supporters now call themselves feminists. We just got it wrong, us feminists. They call us what do they call us? Gender feminists. I don't know. They make up a name for us, and then they give themselves a name. But guess what name they keep? Feminists. Because they know doggone well that the fight for women's rights is not only immensely popular, it is the wave of the future. Thank you.
Thank you, Ellie. So I would first like to thank all of our panelists. I think that they did a wonderful job. And open it up. Oh, yes, we can pod. And I would like to open questions up to the audience and also remind you that we do have 2 representatives from the Congressional Research Service here who will be able to give you some legal analysis that if you have questions from especially Bobby's presentation. First question.
My first question, I begin with a statement regarding the rally that Andrea spoke about. September 13th, it's in the Capitol. It's permitted. It's going. It's happening. It's going to be big. And you can find that on. I don't need that. You can find that on the. You can find that. Recording. The United States Capitol. It's on the south lawn of the White House. Or not the White House, the Capitol. And it's, excuse me? West lawn of the Capitol on Saturday, September 13th, and the lobby day is going to be the 12th of September. So we invite everybody. We want to make it big, and it will be big. And the second thing I wanted to ask you is, I was part of the Virginia initiative, and this question is for the Congressional Review gentleman, is that when we were working in the state of Virginia, we had a couple of the legislators that were challenging the issue of dropping the ratification deadline. And there's a lot, one of the things that a couple of things that we fight with. Number one is the fact that 72% of Americans think that ERA has already passed, which was enunciated. Even legislators. I mean, you're voted into an elected position and you don't need these basic things. And so the learning curve is huge. But the other thing that we are getting is people asking questions about whether or not the Equal Rights Amendment would force churches and this is, I've been told this, force churches into treating women equally as being a concern for passing the Equal Rights Amendment. Would you please speak to that? And they also said they were concerned about voting to ratify the Equal Rights Amendment. They were also concerned about ratifying the Equal Rights Amendment because they said that with the ratification deadline not dropped, that they don't have a live bill to vote on. Would you please speak to the catch-22 that we find ourselves in? Thank you.
Thank you for that question. So let's just say that the issue of what a constitutional amendment means over the long term of the country is one that is actually, it's kind of unique to our country. In most countries, constitutions are very, very specific. It's really a modern phenomena where if you want a particular thing, you'll actually write in almost a statutory phrase and you put it into your constitution. So you generally don't have that question in most other, for instance, European countries. Our country has a tradition based essentially on the Bill of Rights of writing very broadly worded constitutional language. And consequently, if you could take any of the Bill of Rights, what you'll find is that the meaning of that was not clear when it was first passed, and the meaning of many of those are still not clear today. So to your question, how would this affect discrimination as regards churches? A couple of points I'd make is that the ERA relates to state laws and to federal laws. And so the ERA essentially says that the federal government shall not pass a law that violates the rights of women, or that states shall not pass a law that violates women. Now, it does have a second provision that provides for appropriate legislation to enforce those two, but in general, the restriction is on state and governmental action. So, for instance, if a church is making a hiring decision, that is probably, they are not acting as a state actor, so on the face of it, that's probably going not to be a concern. Secondly, religion has a free exercise component to it, and so consequently, that may also be an argument against that. But having said that, I can safely say that almost every one of these questions that's going to be asked at this point is going to be difficult to answer for a fairly specific reason, which is that the Supreme Court, starting with Frontiero versus Richardson, created a intermediate standard for discrimination against gender. That intermediate standard may even be ratcheted up a little bit. It's still not strict scrutiny, which is the kind of standard you get for the suspect classes, race, ethnicity, et cetera. So there's a space in between intermediate scrutiny and strict scrutiny, and it's really not very well developed. There aren't that many cases on it. You know, we do know that it makes a difference, probably makes a difference in some cases, but it's really not a well-developed area of law. So as with a lot of Bill of Rights, I think that the real answer is that, you know, you pass something that has some kind of general values, and then it's really up to the courts as to how to interpret it in particular situations. As I said, certainly that would be an issue that would be raised, but there's actually a very specific line of cases. The Supreme Court just decided Hosanna Tabor, which said that there was a ministerial exemption for free exercise, so that for particular institutions such as churches, there's unlikely to be a level of interference. But remember, again, we're talking about constitutional amendment. So if free exercise is, the question would be, would free exercise be interpreted as compatible with this, or would this be seen as in some way chronologically distinct from it? So that is a very, very subtle question, one I certainly would want to, first of all, be asked by a member of Congress, since we really only ask for members of Congress. Secondly, I'd like a lot of time to answer it.
Thank you. Another question? Right there.
I understand that pay equality is one of the major issues here, or it seemed to be anyway. Given that the text of the ERA deals with government action, how would passage affect the pay gap outside of state or federal employees, non-governmental employees, private sector employees? How would that be impacted by a prohibition on sex discrimination by the government?
Yes, and may I ask you to just introduce yourself?
My name is Michael Causey.
Thank you.
Pay and government action has been asked repeatedly. And in reality, interstate commerce covers a lot. And most of the major employers of our country are interstate actors. So you're starting to come under federal law. But most importantly, you are setting, by passing a constitutional amendment, a national standard. Right now, for example, who is the biggest employer in the United States? The federal government. So you would be requiring at least pay equity and equal pay in the largest employer. But more importantly, when you consider it as the largest buyer in the country, the biggest contractor in the country, it would be easy for them to set a requirement that they require the people they contract with to give equal pay. That would cover millions of more workers. So it would establish a standard that would indeed enhance our ability to fight for equal pay. But equal pay is not just what you're being paid that minute. It's your potential to be paid, and it could give us equal status in education. And I know we think we have equality in education, but I don't know if you all realize that as we sit here right now, Title IX is being encroached upon. It was repealed by the Reagan administration, you might as well say. We lost a court case in '84. We had to restore it. It's just a statute, right? Well, right now, I believe it's being violated again because the Bush administration passed regulations that allow for the establishment of single-sex schools, public schools I'm talking about, that are not of comparable value. In other words, you could have a school for boys or a school for girls, and you don't really necessarily have to have a comparable other sex. I could go on in this for hours. If you don't have the same educational training opportunities, your chances of getting the same pay on the other end are greatly reduced. And pay is not just what you get in your paycheck. It's also benefits. And women are not getting equal benefits in retirement and Social Security, and I can go on. You get the message. This will help us economically. There's no question about it. And by the way, I believe, and I wanted to say this to our esteemed economists, that we should be constructing pay gap charts that includes benefits. That gap would be much wider. Thank you.
Thank you. Another question? Hold on, we have a...
Betsy Griffith. I'm a historian writing about the Equal Rights Amendment for many years. My question is, among current sponsors, House and Senate, and in state legislators, and who's holding governor seats, do we have any Republican allies?
Sure. Would anybody like to take that?
I've got a really short answer, and then Ellie. No, not that Ellie's going to have a long answer. It's just mine's going to be really, really short. When we were presenting before the Virginia State Senate, there were 5 Republicans that were on the Rules Committee. And so we were sure that the one woman senator was going to be with us because she came over and said, hey, you know, I'm going to support you. What was really shocking was 100% of the Rules Committee voted us unanimously out of the Rules Committee. So we got all 5 Republicans. And when that bill went to the floor, we had a really interesting thing happen. Virginia has 40 senators. So when they took the initial vote, it was 32 to 8. When they published the vote, it was 25 to 8. The original senators on the Rules Committee stuck by their vote. 7 others weaseled out.
We have actually, and you'd be able to give a better count, Bettina, we have several House co-sponsors that are Republican, but also we've had Republican support. Obviously, at this stage, not as much, but we have had Republican support, and we do have Republican supports in the various states. And I think we have got to come with a new brain set that we're going to get more people. Time has changed. When we went through the last time, they would ask us a question about women in combat. They're not going to ask you that question anymore. That's been changed. There's a lot of things that have changed. And so I just don't think we should assume we don't have somebody. I think we should assume we have them and act on that. You have a bigger target zone and a bigger chance if you think positively. And I really think that just like, look at what's happened on gay rights. It is like everybody's for it now. I mean, it's like, what happened there? Who were we fighting all those years? Now they're rushing to be. I heard, Alice Cohen, you can correct me, that Karl Rove has come out for gay rights. I mean, you know, there is for gay rights. So, you know, in case the taped in here, it's Karl Rove founded a PAC to support for Republicans who support gay rights. So I don't think that you should think in terms of this is one side. This isn't. People want equal rights for their daughters, and I believe women want it, and that gender gap is massive. They can see that gender gap. Just look at the voting. When we first started saying, what was it? The gender gap will get you in November. I don't even know what the slogan was. But anyway, is that was a smaller gender gap than today. It is growing because of the perception of equality, of who's with us on equality.
And I do want to clarify.
Bettina, could I just?
Can I just say one thing? I do want to clarify with Bill here, especially that we do have Senator Murkowski and Senator Kirk, who are signed on to SJ Res 15, and those are both Republican senators.
And yes, I need to add, because Bettina and I are both constituents of Congressman Rodney Frelinghuysen in New Jersey. He's been a longtime co-sponsor, and in fact, this most recent newsletter he sent out to his constituents had a piece on the Equal Rights Amendment, and Richard Hanna, who's in Seneca Falls, is in his district, I believe, Congressman Hanna.
Oh, we're going to need to go to another, we can get...
Point of historic preference. Of course, Alice Paul only had Republicans introduce it for a really long time, and it wasn't until Democrats joined in and it became a bipartisan event, and now it's shifted over. So I endorse what Ellie said. We need every vote we can get. But without Republican votes, you're never going to get out of your judiciary committees or get anything passed at the legislature.
Right. Right here, Alice Cohen.
I think we certainly need representatives from both parties, but I also think that we should not in any way be apologetic. The Republicans need to catch up with the reality of society as it is today. And it's up to them to do the right thing, not for us to weaken our message or make excuses for them.
Right here in the front. Oh, sorry. The microphone. And if you could please introduce yourself.
Okay. All right. My name's Candace Graham. I'm with Women Matter, Use Your Power. And when we brought the bill to the legislature in Virginia, one of our talking points when we were trying to get co-sponsors was that this was a nonpartisan bill and we wanted bipartisan support. And if this was something we could all come together on, because when you give women more opportunities in the marketplace and you pay them equally for equal work, then we're helping lift women off of public assistance. And that's something we all want to see happen. And that was received very well. So I recommend it to everybody.
Thank you. Do you have another question? Right here. She's had her hand up.
Thank you. Hi, my name is Brittany Edwards. I'm from Senator Warren's office. My question is for Dr. Gold. I wanted to ask you, at the end of your speech, you said that there's no cost to the economy for equality, but other speakers seem to allude to the idea that financial groups do not feel this way. What are your thoughts on that, and could you go into more detail about that? Thank you.
Sure, I think it's a great question. I think what we heard earlier was talk of the ACA and what happened in the Affordable Care Act with eliminating price discrimination. And the insurance companies eventually signed on because they realized they were going to have a lot of comers to purchase insurance. So they said, okay, fine, we won't discriminate. I think that that's a classic example of a direction that we can go, is to eliminate that kind of discrimination in insurance markets across the board. I think that when people argue against wages, higher wages for women, I mean, you're also talking about really lifting up the bottom and making sure that people are paid not only for comparable work, but paid decently, right? You heard, sorry, I forget your name, talk about, the importance of really lifting people out of poverty, right? And if anyone wants to go after anyone else's pocketbook, right, you may have some problems. But I think that what we've seen in this country just generally is a growing gap between the haves and the have-nots, right? So this is not just a gender story. This is a story about the top really reaping the rewards of economic growth over the last 3 decades. And that is not the way the economy is always run in this country. We saw many decades, in fact, where we had far more equal growth and far more growth across the whole income distribution, across the whole wage distribution. So we have room to go back to a world where that can occur. And sure, those who have the power are going to resist that, and that will happen no matter what fight we're leading here.
Question in the back?
Hi, my name's Steve Davis. I've been a member of the PDA for some years along with my wife. The statement is that we can have a country where the wealth is concentrated in the hands of a few, or we can have a democracy, but we can't have both. Now, what we're talking about here is linking economic opportunity, broad-based, to civil rights and universal acclamation of those rights in a way that enthusiastically brings people to the polls. So could you speak to linking this, the dynamic of inequality of income with inequality of opportunity and the attack on voting rights? I mean, all of these issues are correlated.
I don't know if Elise, if you want to take that, or Ellie? Illegal. Andrea?
I'll grab a piece of it because this is one of the things that we're working on at PDA. The whole concept of equal rights and voting rights and civil rights all together. with the idea being that every family, every man, every woman, what they really are looking for is a reliable path to economic security. And when you have families where women are paid less simply because they are women, you are interfering with this whole concept and notion of a reliable path to economic security. So that's really what we are saying. And when you look at that and you tell people and remind them, this is what this whole thing is about, there probably will be a reflection of that in the results of voting at the polls.
I also want to add, okay. Okay. I just wanted to add to that, you know, as a country, and just going again back to that point about, you know, sort of government safety net, as a country, we've moved not only from one that had more equal growth to one that's more unequal growth, but also one where our safety net depends much more on work than it has before. And people at the bottom of the income distribution depend on wages and salaries for the vast majority of their income. So if we want to get head on and deal with the problems of poverty, deal with the problems of not only, you know, middle income wage growth, but at the bottom, we really want to tackle what is going on with wages. And as we see the disparities in wages for women, women across the board, women of color in particular, they're drastic. And I think if we work on these issues of really lifting up the bottom, we're gonna get to all these other issues. I think exactly what you said about the wealth gap, that is the most extreme gap. And then incomes, and then wages. We have to start with wages to really help out people.
And Bobby, when
right, and benefits,
yes,
exactly.
This is to bring it, all this is really important, also to bring it home to constitutional guarantees of equal rights. Equality of rights shall not be denied, the right to vote shall not be denied on account of race, color, or previous condition of servitude. The right to vote shall not be denied on account of sex. Equality of rights under the law shall not be denied on account of sex. I would be interested to ask the CRS people if they think there is a way to come at these attempts to suppress votes on the basis of techniques, for instance, needing to have your ID card exactly match that very disparately impacts women. Your voting, you know, your license and your voting registration, et cetera. It may be too quick, but I think that we really, and I know this is something for the rally in September and elsewhere, it's becoming more and more apparent to people that these are attempts to suppress votes from particular components of the electorate. And the ways they've chosen to do it disparately impact people on the basis of race and sex. And there are constitutional amendments saying you can't do that. Open question. Can we put those together legally?
If there's a quick microphone, and then
I'm hoping to get an answer, quick answer.
just a quick answer, because
I thought you were asking another question. I'm sorry.
Sorry. First of all, if I had a lifeline, I would use it. We have excellent election law lawyers back in my office, and I don't have them here, so I'll try to answer it anyway. The real answer is that voting rights, especially the ones you're talking about in terms of the state setting qualifications, the state setting parameters of how you, you know, basically what happens when you go to the polls is actually a very active part of law right now. We literally just had a district court case that has going to have some effect on that, and it's following up on Justice Scalia's suggestion in one of his opinions that there might be an alternative litigation strategy to the Arizona law that was just struck down. So I would say that we really are at this very cusp area right now. The thing to remember about that is in the area of 14th and 15th Amendment law relating to African Americans and suspect classes. So if you're going to have any place that you're going to have a fairly robust Supreme Court presence is going to be in that context. Okay. So as of right now, since intermediate scrutiny doesn't have quite the same effect right now, I think that what you're talking about, certainly it's out there, but it's really going to be fought out in the 15th Amendment context, which is race. If you threw, if the ERA come up, then obviously that might be another component, and then you get into, because if you start looking at some of these cases, Shelby versus Holder was the Voting Rights Preclearance Act, which was struck down. They're getting very statistic heavy. And so, you know, if you're in the context of, you know, ethnic and racial minorities, that's one set of statistics. If you added in gender statistics, and that would be another set of statistics. But this is a very, I want to say, advanced area of law, meaning there's been a lot of litigation. The litigation is continuing, and we're really seeing, you know, essentially these are kind of almost tertiary cases that are happening now. And so gender really has not been a component of that to this point. And I really think that race and ethnicity are going to remain the primary battlegrounds here.
But if I could draw one
thank you.
conclusion, just that the 19th Amendment does not make sex have to undergo strict scrutiny, but an Equal Rights Amendment would make sex be a suspect classification.
Sure.
And so then the voting rights examination of that would be equivalent to looking at it with 14th Amendment analysis.
That's what I'm saying, is that you'd start adding those statistics. So you would have, you know, you'd have these cases that are very statistic rich in ethnic and race. Then you would add another component, which would be gender if you had the ERA in there.
Okay. Thank you very much. And I think Leanne, to over right here, is just waiting.
Zoe, can you hear me, from Oregon with voteera.org? And I just have, oh, thanks. Thank you so much for having this. This is just incredible. I have a lot of ladies back in Oregon that are very delighted this is happening today. Two very quick points. One, to Bobby's point, actually, The Nation magazine came out January 1st, 2014 with 5 of their top goals for America. And a lot of those were centered around voting rights. And I wanted to tell you that number 4 was passing the Federal Equal Rights Amendment. So they were looking at those actually in context of each other. And secondly, to the gentleman back there that talked about a little bit of campaign messaging with respect to fairness and disparities in pay and the ERA, one thing that we will be doing, we have, again, an active ballot initiative. We will know in July whether we've qualified or not for the general election of this year. And one of the things that we will be doing is we will be saying, in fact, the Equal Rights Amendment is not just for women's equality. It is really for fairness for the whole family. Because again, if there are such disparities in pay and benefits, it's not just the women that is suffering alone, it is the children, the family, and in a broader sense. So that is something we will be addressing in our campaign. Thank you.
Thank you. So we are just about at we have time for another 1 or 2 questions. I would ask, it seems like we have a lot of questions. If the panelists have another 5 or 10 minutes to answer, would you be able to stay? Okay, great. So next question. Jan.
Thanks. Jan Erickson with Now. I want to bring the discussion back to where we started and ask either one of our Congressional Research Service fellows to speak to this question. There has been some legal scholarship which asserts that the U.S. Constitution doesn't really allow for deadlines on amendment ratifications. And I'm wondering if either of you could offer your view on that particular point. And I should add, we already have equal pay under the 1963 Act, equal or substantially equal. What we want with an ERA is to move closer to a standard of comparable worth pay. I just thought I'd throw that point in there. But getting back to whether either of you, experts who've looked at these questions, have any thoughts about whether having a deadline on a ratification of a constitutional amendment really is allowed.
Let me speak to that from the standpoint of policy as opposed to Ken's constitutional law. But then again, I will talk about the Constitution because it's been remarked that the Constitution is, when it's actually handing out authorities, it's very broad. But when it decides, then the founders decided to not allow Congress or President to do something, it's very specific. And there have been comments that the Article 5 process of amending the Constitution gives an enormous amount of discretionary power to Congress with respect to setting deadlines. Now, as I think we discussed earlier, there were no deadline sunsets on constitutional amendments until the Prohibition Amendment. And if you read my report, you would have discovered an interesting footnote to history that the anti-prohibition forces said, let's put a deadline in here because that means it will never fly, but we can vote for the amendment, and so you'll look good, but we'll still be able to go out and have a drink. Well, it didn't work out that way. And the question has been raised that, well, so the 7-year deadline, therefore, is not necessarily set in concrete, nor was it something that the founders ever considered, which they did not. But it became habitual, customary, with respect to proposed amendments. Congress can do it, Congress cannot do it. And I'm going to mention a Supreme Court case, and then Ken may want to jump in here, but Coleman v. Miller, in the case of Coleman v. Miller, the court said many things, but one of the things the Supreme Court said, and this was with respect to the proposed child labor amendment, which was never ratified and was later declared to be moot because the court had ruled that the federal government did have the authority to regulate child labor. But there has been the suggestion that Coleman v. Miller gives Congress plenary power, enormous power, to regulate the amendment process, including deadlines for the amendment, and that the court in this case decided that this was a political question, and as you know, it does tend to shy away from that. And I'm going to let Ken take over here because he knows more about the political question doctrine than I could tell you.
Thanks, Tom. Let me just start by saying I am the editor of a treatise that deals with pretty much all aspects of the Constitution. And if you take a well-developed area of law, such as the 14th Amendment, we have a section on that goes on for about 800 pages. The ratification discussion that you're referencing, I just went back and reread it, goes on for about 10 paragraphs. Okay, so that's just to give you a sense of how this is not a well-developed area of law. The challenges to deadlines is really only one case, Dillon versus Gloss. In that case, there was a challenge to, I believe it was the 18th Amendment, where the challenge was somebody who was, being prosecuted under, I guess it was alcohol-related challenge, and this fairly short little dismissal of the suggestion that Congress couldn't put a 7-year ratification on it. The idea seemed to be that Congress has the authority to set, well, first of all, that the Fifth Amendment really says very little about the process, and that Congress clearly has to have some power because, otherwise there's just really no way to articulate how not only this process, the ratification process through using the 2/3, 3/4 process, but there's also another process that hasn't been used yet, which is the Constitutional Convention process, which is the idea that the states would petition for Constitutional Convention, and then there'd be a new Constitutional Convention on that amendment, and nobody knows what that looks like, but certainly there's a sense that Congress would have to do something besides saying yes. So there's really an idea here that the Fifth Amendment, very, very broad, it's written with very broad strokes. We don't really know what it does yet, but the relevant Supreme Court case we have on whether or not you could put a 7-year limit on it is, again, very thin, but seems to say that that is something that is within the congressional authority. And I would also say that really, as far as court cases versus secondary commentary, the court cases are this much, and the secondary commentary is this much. And so I think that it's all good work, and it's all important and necessary because these issues can and may come up, and we need somebody to have thought about them deeply. But in terms of talking about Supreme Court precedent that would bind a district court in trying to decide this decision, we really have, really just that one case.
Back there. No, there's a woman behind you who's had her hand up for a while in the gray.
Hi, thank you. My name's Hikari Iwasaki from Congressman Sam Farr's office. And this has kind of been touched on by the folks here at CRS, but I was wondering if either of you could speak about if ratified, how would the underdevelopment or the vagueness of the intermediate scrutiny test kind of play out in the courts? And this has kind of been dealt with kind of clumsily throughout history with, gender, sexuality, and gay rights, things of that nature. But we don't really have a solid precedent to work off of, and I would imagine it would be difficult, especially in the Supreme Court with folks like Scalia who are kind of hesitant to, delve into new areas of constitutional law in that manner. So if you could kind of expand on that.
So I believe the question is, what would the relationship be between intermediate scrutiny and the new strict scrutiny? Is that correct? Because the existing intermediate scrutiny, as you said, is just a little unclear where it goes. I think strict scrutiny law is pretty well developed, and we would look to other aspects of the 14th Amendment as it's essentially is there a substantial burden on the right, compelling governmental interest, and is this the least restrictive means that you can use for that purpose? So really, if you're talking about the more significant cases that have seen some gap maybe between intermediate and strict scrutiny, one example has been, and I'm not even going to try to pronounce the name. It's Vietnamese adoption, or sorry, it's a Vietnamese immigrant or somebody who had come into this country, and the question was whether the disparate relationship between somebody who's coming into this country and whose mother was the citizen. That's different from if the father is the citizen and how it relates to your citizenship opportunities. You can both become citizens, but if the father is a citizenship, you have to jump through a few more hoops to go there. And that was an example where intermediate scrutiny could probably arguably have made the difference between that and having actually gotten to the strict scrutiny. So strict scrutiny does tend to be, in law school, it'll teach you, it's generally considered to be fatal in practice, meaning that in most cases it's going to be fairly difficult. But we've had plenty of exceptions to strict scrutiny. We have educational diversity is an exception to the general. Supreme Court generally doesn't like affirmative action, but in the educational context, they found educational diversity to be a sufficiently compelling governmental interest. So there are major gaps in, strict scrutiny, but they tend to be, I think, almost want to say systematic gaps. They're kind of large-scale gaps. They're not kind of small in-application things, and they're things that develop, kind of over time. So in this context, again, I think that it would be a little more complex than race, obviously, just because there are some gender issues that are not as reflected in the race issue. But I think that, I think that strict scrutiny would probably, be fairly strong in most situations you can come up. But having said that, each one's going to be individual and different.
Thank you. I think you've had your hand up for a while. I think we're going to just have two more questions, and then we'll have to wrap up.
There was several mentions of a rally, and so I wanted to make sure that I put the information out there for people who are interested. I'm Jacqueline Nantier with the We Are Women rally. We're a coalition of grassroots groups that come together to put together a rally at the West Lawn of the Capitol.
I'm sorry, just for the sake of time, do you have a question?
No. I
Okay.
just wanted to let everybody know if
So
you need any
we're
more
gonna need to
information,
move
you
on.
can look, I'm here, you can ask me. wearewomen.us. Thank you.
Thank you. Well, I think the woman in the black had a question.
Okay. Okay. My name is Pat Fishback, and I'm with Women Matter, Use Your Power now, but I've been working for the ERA in a lot of capacities for years. My question is, I've watched the elections very carefully on all the levels this year. Why do you think that no candidates that I heard ever mentioned the ERA?
Very good question. Ellie, you look like you want to answer?
That to happen, it's very easy. They start seeing ERA yes stickers everywhere. You start asking the question, they'll start answering it. And basically, there was a time where literally politicians did not campaign without, our buttons were everywhere. This button, by the way, is the button that was manufactured by now, I think, in '77. So, but basically, it all depends on us. We want that question answered. You make sure the question is asked. You want them to deal with it, show up at everything, and make it an issue. That's the reality, and it happens. One thing about organizing: nothing ever happens unless you decide to make it happen. Once you decide to make it happen, it happens. And so, I don't think that's our biggest problem right now. But I do think that it would be good if we asked every member who's running for Congress, Senate, and the House, where do they stand on the three-state strategy? They'll learn what the three-state strategy is, believe me, right away. And where they stand on the reintroduction. So I just think we got to get out there and ask the question.
And Pat, for anybody to be endorsed by Progressive Democrats of America, that is one of the first questions that I go to and look at their answer. So we require the correct answer on that one question.
Wonderful. And so we're going to...
Our candidates do. They're also required to speak about it in public and put it on their website.
Oh, just one second. I think Chicha wanted to make a comment.
Is this on? Oh.
Yes.
And I will say that for now as well, when we endorse candidates, we also ask if they are in support of constitutional equality. It's something that is very important to us. And so obviously when we are seeing candidates who are requesting our endorsement, it's something we ask and something we do care about.
And one last question right here.
My name's Maria Roberts. I'm a 10-year veteran of the effort to ratify the amendment in Florida. My question directed to the Legislative Research Service or to anyone else who wishes to comment: could we accomplish the same thing as the ERA would accomplish by passing and ratifying an amendment to the 14th Amendment, stating that equal protection of the laws applies without reference to gender, to both genders?
Of course, but you have to start over again. That would be a new amendment. But the start over one is that are being suggested, in fact, are broader than that. The Equal Rights Amendment is, as it is worded, is stronger than that suggestion. And the new wording that Carolyn Maloney has introduced is even stronger than that. And I could go into the details, but if you got to start over, you either start with the current wording or new wording that actually puts women in the Constitution without any doubt.
There's an added sentence, and Bobby, I think, can recite.
It's H.J. Res 56 in the House. You can go on Thomas and find it, but the Carolyn Maloney has consistently
I can say what it is.
Well, I can too. Has consistently introduced the standard wording, and there was discussion this time. I want to explain what the reasoning was behind it.
Well, I think that right now, for sake of time, we just need someone to say the
Okay. She added a sentence in the first clause saying, women shall have equal rights in the United States and every place subject to its jurisdiction, which is a variant on what Alice Paul introduced in 1923. Then she has the second sentence in that first section, the standard, equality of rights shall not be denied or abridged by the United States, et cetera. But the second, it's interesting also in the second section, she has added Congress and the several states shall enforce, da-da-da-da. And that is to go back to what Alice Paul thought was important too. So I think people need to understand, not just they'd see new wording and say, oh, what is this? But understand that it goes back to some of the things that Alice Paul, Ellie would tell us better than I could, wanted and was disappointed weren't in what passed in 1972.
Thank you. Any last remarks from the panelists before we end?
Let's go out there and do it.
Thank you. Yes, let's go out there and do it.
At least I got to get the words in.